Child support is calculated based on several guidelines established by the Nebraska Supreme Court. Those guidelines include your gross monthly income, several deductions that are automatically calculated pursuant to this calculator that's been prepared. We just plug in the information. We go through carefully what deductions you may be entitled to, and we get a result as to the calculation. However, that's not the set in stone actual amount. There's all kind of ways that it can be amended or, deviated is the fancy term for it. However, it depends on the parties of what they can agree to and the issues of each case. It's on a case-by-case basis, and we would need your pay stubs, some tax returns, breakdown of your insurance, your employer-sponsored insurance, or whether you go through private insurance and whatnot, and we plug in all that information and we get an idea where the guidelines would set the child support and who owes what amount, and that's how we determine it. Child support may be modified. There's no such thing as a final order when it comes to child support, provided they're still minors under Nebraska law, which is the age of 19. Provided there is a material and substantial change in circumstances, which were not contemplated at the time the decree was entered. That material change is child support only, typically relates to the changes in income, and when you calculate a new child support calculation, that it would increase or decrease by 10% of the original award. And you can come in, meet with us, we can put those figures together using your pay stubs, your tax returns, etc., all the income information, as well as the deductions to determine that amount and whether the court's likely or perhaps unlikely to modify said child support calculation. Someone gets a new job would be a change of circumstances. Now, it could be for the benefit or the detriment when it comes to the child support calculation. If they're earning less, your ex-partner could potentially seek to reduce it. However, if earning much more, it'll be readily apparent to you in terms of perhaps spending habits and things of that nature, but we have to look at the best interest of the child. That is of paramount importance to the courts, and that's why we run these child support modifications when they are necessary. Payments are missed, the payor could be held in contempt. However, there's several factors that may come into play regarding how they are paying child support, whether it's automatically withheld from their pay stubs, but ultimately they could be held in contempt for not following the court's order. But there are a myriad of circumstances which may affect what kind of contempt they're held and the potential punishment for not paying it. However, if a court orders you to pay child support, you are to abide by that court's order. So if you have any questions regarding child support modifications, enforcing orders, etc., please do not hesitate to contact us at Husker Law.